there appeals in the matter of the claim on the application of E.ON and others and the Secretary of State and the claim on the application of British Gas Trading Ltd and the Secretary of State?
My Lord, I appear on behalf of British Gas. May I please give the Court the runners and riders? For British Gas, my learned juniors are Miss Naina Patel on my left and Mr. Warren Fitt behind me. For E.ON on my right, we have Mr. George Peretz, KC, leading Harry Gillow. The Secretary of State, we have my learned friend Jason Coppell, KC, leading Patrick Halliday, Malcolm Birdling and Alistair Richardson. For the Joint Energy Administrators, we have Mr. Tom Hickman, KC, leading Ms. Gayatri Sarathi. And last but not least, for Octopus, we have my Lord Panic, KC, leading Jemima Stratford, KC, and Will Bordeaux.
Yes, thank you very much. We should have had I think there does exist, a slip with counsel and solicitors, but we've got internet difficulties here, and for that reason I haven't got it. These, however well filled out, never really do the trick. Thank you, yes. But perhaps if for some reason we discover we haven't got those counsel slips, we can ask them to be provided.
Yes.
Returns, I should say. Yeah.
In terms of housekeeping, I hope the Court should have the core bundle and a supplemental bundle, as well as a voluminous bundle of authorities.
Yes.
At lunchtime yesterday, the Secretary of State and Octopus served a supplemental bundle of 4 further authorities.
Yes.
Those have been sidelined, but we don't know what propositions are to be advanced on the basis of them. The Court...
is that what we have?
No, that's the homework that the Court gave us yesterday, which is to include the cover sheets for the statutes. So some of them, I'm afraid, are quite voluminous, especially the
I see what
Companies
I mean.
Act.
I'm sorry.
That's what we understood that the Court had asked for. If we've got that wrong, I'm sorry.
Well, certainly I didn't expect that...
the whole of the Companies Act would go in.
Well, no, that's not what I asked for at all. But, I see what you... okay. Well, thank you. I'm sorry if it was a bigger task than I meant. It's simply often when you've got an act that you're not familiar with, you're just presented with a section with no context. You want to know how it fits in.
Absolutely.
Which part it...
and for something like the Subsidy Control Act, that, with respect, makes perfect sense. Arguably, it makes less sense for the Companies Act.
Well, I can see...
Those who sit behind me took it literally.
You should always do it. But if you had been tougher and said, surely we don't have to do it for the whole of the Companies Act, I would have said, no, of course not. Anyway, thank you for doing that.
I suspect that the very good was the enemy of the best there.
Yes.
There we are. May I say a short word about confidentiality, which is that I'm not proposing to read anything out loud which is marked by a confidentiality marking. What I propose to do is to refer the Court to a particular part where it's necessary to do so and invite the Court to read it for itself.
Yes.
We've also sought permission to rely upon a supplemental skeleton argument. That was served on the 10th of
Yes,
December.
I'm sorry that wasn't dealt with earlier. We've looked at that, and we have looked at the objections. We see both sides' point of view, but in the real world, we have read it. It's better to know what you're going to say than not to know it. We can't believe that with a 3-day hearing, and anyway, having had it for some time, the other parties, whatever their legitimate objections, are going to be prejudiced, so you may rely on it.
Thank you very much. In that case, I shall trouble the Court no further with the reasons for our relying on. In terms of a roadmap, I am going to address you first.
Oh, sorry, just one more thing. You said about the additional authorities which you had been served with yesterday, and indeed those came to us electronically. But are we going to have them in hard copy form?
I see nods from my learned friend.
Yes.
Yes. Well, thank you. Yep.
I've printed out a hard copy, so
I'm afraid I did. I ought to know with both my lords. But certainly with key authorities, we like to have them to write on.
Absolutely.
Yeah.
Well, the hard copies are in court if you would like them, or as and when you would like them.
Well, while we're still doing housekeeping, why don't we just have them now? So yes, okay. Well, can they be handed up? Oh, sorry, they are in court, but people aren't ready to. Let's hand them up at a natural break. Let's not waste time now. Can we just, but on housekeeping, I got a message from the clerk, it may be that it's now been superseded, that there was technical problems with the transcript. And I'm afraid the view we took was we just let it get on with it. If there isn't a transcript for a bit, or at all, that's tough. Hopefully there will be at some stage.
I'm very happy to proceed on that basis.
Of course, we would like and will appreciate the transcript if it exists, but we can't hold up the whole hearing.
No. No, time is relatively short because
Yes,
of
exactly.
the number of people appearing.
And just one other pretty obvious point, if there's just a gap in the first 20 minutes or however long it happens to be, they can always go back later and look at it on the live stream and do it from there.
In terms of roadmap, I'm going to address you first with a sort of lie of the land series of short introductory observations. I'm then proposing to deal with ground one delay for the domestic law position. Mr. Peretz will address you on ground one for the TCA position, so the Trading Cooperation Agreement position. On ground two, standard of review, that will be me, and I'll also cover respondents' notices. And then on ground three, I will deal with the first subground relating to the alleged open, non-discriminatory and competitive process that was followed before handing the floor to Mr. Peretz to deal with everything else on ground three, including the concluding comments.
But you're not, are you envisaging getting up and getting down, getting up and getting down?
At the moment, but I'm in your lordship's hands. If you'd rather...
No, if you've thought about it, if you think that's what will work best, that's what we'll do.
I think we can box and cogs between us so that the disruption is limited. My learned friend, Ms. Patel, will address you on the question of relief, if the court has any specific questions on that.
We have a lot of questions about that. I shall make it clear now, and you may find that the two of you are being asked to deal with that. I'm not going to start it right now, but we'll just put a flag down, and we find it quite difficult to understand some of the issues, particularly relating to delay, without understanding what the claim was and what the claim now is in the circumstances in which certainly the divisional court find themselves, or possibly we find ourselves years down the line.
Yes.
And we will want to know what this case is really about and was really about at the time that it was before the divisional court.
And I think my short answer to my lord's point is that that was then, this is now. And therefore the submissions that would have been made on relief, but which I was invited not to make in the divisional court, are no longer the ones that I will be making to this court via Ms. Patel. I'm not sure if that's helpful or unhelpful. It's simply a statement of the position.
No, I'm sure that's helpful. I think the more we understand about this, the better. But at least on one view, the question will be even what relief you would have been entitled to 18 months ago. And when was it in front of the divisional court?
March, or February, March 2023. 2023.
2023, exactly. So yes, almost two years ago. Right, well, let's not go down that route now, but be aware that we are very interested in it because it does affect, certainly on the way we've been thinking about it in our preliminary thinking, it does certainly affect the question of delay, may affect other issues as well.
I can see the force of that one.
And just on that, I mean, paragraph 108 of your sort of amended statements of facts and grounds was hardly the most developed pleading in relation to remedies available.
My lord, that's true. We did have some submissions ready to be deployed in the divisional court, but having tried to make the points I wanted to make a couple of times, it's fair to say I met some judicial headwind.
Well, we saw paragraph 133 of the judgment.
But you say you had, and presumably there was some in the Skeleton argument. I haven't, I'm afraid, in the time available, been able to read the Skeleton arguments below, but did they not deal with relief? Because you were expecting to.
They did.
So you say you had submissions ready to go. We could find out what those were, or at any rate the bones of them, in your Skeleton argument below.
Yes. I mean, in a nutshell, there were a variety of ways in which relief was being put. What we essentially wanted was recognition that there was an unlawful decision, i.e. declaratory relief, quashing decisions in relation to both the funding decision and the approval decision, and then for the, if appropriate, for the process to be rerun by the JEAs in circumstances where everyone would have been able to rebid, with some interim steps being agreed between the parties to enable effectively Bulb to carry on being run by Octopus until such time as a rerun of the competitive process had been achieved. essentially by the time of the Divisional Court hearing, the realistic approach was that was the ideal scenario, but it was increasingly being recognised that with each passing day that was increasingly difficult to achieve in practice. But
still, if we had been looking at your skeleton, that was your formal position before the Divisional Court. If you had been asked, are you saying that if you'd been asked to make oral submissions, you would have resiled from that to some extent, but the point never arose?
Well, as always with relief, one has a wish list, and that is tempered by the art of the possible.
Yeah. Well, we're quite interested to know, and again, I'm not asking you to do it now unless you possibly want to trail it. What if you were forced to concede that wasn't realistic anymore? What form of relief you would then have been seeking?
Well, there would then have been the relief that we're seeking now, which is essentially a recovery order.
What is a recovery order?
A recovery order is a determination of the amount of aid that has been received and which should be repaid by the beneficiary because it's an unlawful subsidy.
And who is that recovered by?
That is recovered by the state against the beneficiary of the unlawful subsidy.
Yes, that's what I thought. So the parties, or sorry, the claimants won't get that, no. But putting it very crudely, by hurting their competitor, they will get at least some indirect benefit.
You'll forgive me, my lord, for suggesting that reintroducing a level playing field would be how we would put it. I don't mean that in a derisory way. I simply mean our aim is not necessarily to hurt our competitor, it's simply to reintroduce a competitive level playing field. Whether it amounts to the same thing.
All right, I'm not suggesting my formula was very loyally, but I just wanted to get the feel for it.
I mean, that goes to the issue of delay, because if you are going to unstitch a deal with all the commercial consequences, that's completely different from an after-the-event claim for damages or repayment by one party to the state.
Well, it means that the consequences of the relief are different, and therefore the analysis that takes place for the purposes of granting permission or granting relief necessarily looks at prejudice. And I can understand why my lord's point goes to the question of prejudice arising from the grant of relief. That isn't, we respectfully suggest, the same test as the grant of permission, because the prejudice associated by the grant of permission, which would lead to a panoply of possible forms of relief, is different from the analysis that drives what sort of relief do you give at the end of the day once you've accepted our submission that this subsidy was unlawful. So one can end up in a position where there hasn't been undue delay for the purposes of obtaining permission, but simply by virtue of the fact that things have moved on, and we'll see this in the case law that I'll come to later this morning, the court recognises that it's no longer in a position to do what the parties would have wanted to do on day one, and therefore the art of the possible comes into what relief should be given, and that may mean that no relief is given other than declaratory order that a particular decision is unlawful. We never
which on that basis would do you no good at all, is that possibly as to costs?
Well, it would put down a signal to the government in a highly competitive market that if a large amount of taxpayer stroke consumer money is to be put into the market in favour of one rival over others, that it's done on a proper basis. And that certainly has value. And, of course, holding the government to the rule of law whereby subsidy competitions are open, non-discriminatory and properly competitive is a good thing, not just for the market, but for everyone, taxpayers and consumers included. So that's what we say the benefit is. It obviously is of a benefit to significant players who are hoping to remain in the market for decades to come. So it's sending a signal to government that a proper process needs to be followed, which we respectfully suggest has value. So there's obviously a lot to digest there, and with your permission,
we came in resolved not to bowl this ball at you straight away, and of course we were unable to resist the temptation when you said that Ms. Patel would be dealing with relief. Well, you know what concerns us, and it's been helpful to have some headlines, but I think we may need more help with this.
Of course, I can see that, my lord, with respect. So this is the first time that this court, I'm moving on to my introductory overview, this is the first time this court has been invited to rule on the legal regime for subsidy control established by the Trade and Cooperation Agreement, which I will call the TCA. Parliament has, through Section 29 of the European Union Future Relationship Act 2020, required those requirements, subsidy control requirements of the TCA to be observed by public bodies. Your Lordships will have seen paragraph 206 and paragraph 229 of the judgment below, that it was common ground that the TCA was to be implemented through Section 29. It was also not in dispute that the correct way in which to apply Section 29 had been set out by Lord Justice Green in the Heathrow case. If your Lordships wish to have a quick look at the principles Lord Justice Green set out there, one finds those in the Bundle of Authorities, Volume 5, Tab 55. For those following electronically, I hope that's at page 2089.
Bundle 5, did you say?
Bundle 5, Tab 55, page 2089.
Yes.
So this was a challenge to the removal of a tax-free shopping concession, which Her Majesty's government thought could no longer be justified for WTO or GATT obligation reasons. If we could turn, please, to paragraph 5 of that decision, one sees that the third ground of challenge relied upon was that the TCA permitted the contested measures to be continued as a matter of WTO law. So the application of the TCA into the domestic regime was front and centre of the third ground of challenge raised by the claimants in that case. If we then please turn to page 2160, paragraph 221. At the bottom of the page...
So sorry, I was being... tell me again which page?
2160, paragraph 221. 3 sub-issues are identified, the second of which is what is the effect of the TCA in domestic law. And His Lordship dealt with that.
I'm being very slow. I've got 2160.
2160, at the bottom of the page, it says the following issues arise.
Oh, I see, over the page.
And then over the page, top of 2161.
Yes, thank you.
Second one there.
Yep.
Would your Lordship then be kind enough, please, to read paragraph 224?
What is Comprov 16.1?
So there was a rather arcane numbering system for the TCA until it was renumbered. That's effectively the provisions in the TCA now confirm that the TCA is not itself meant to be self-executing. So it's left to the individual states who are party to it, namely us and the EU, to determine how to implement it under the domestic legal order.
Yes, no, sorry, I just didn't understand the phrase Comprov.
No, it's changed now. It's now numbered all the way through.
Well, what is it now?
It is now... page 3676, it's Article 5, subparagraph 1.
Thank you. So I'm guessing Comprov 16.2 is
5.2.
5.2.
Yes. Paragraph 226, His Lordship then set out the terms of Section 29. Please could I invite the Court to read that as an easy shorthand for looking at the provision.
You even read the whole of Section 29, which, speaking for myself, I've done already.
In that case, I shall speed up. In essence, there's 2 exceptions. Firstly, the implementation has to be necessary for the purposes of complying with the international obligations of the UK. So it's only those parts of the treaty that are in a sense, imposing obligations on the UK directly that have to be implemented. And it's also, that's the second exception. The first exception is insofar as it's not already implemented in existing domestic law. 2163, halfway down, existing domestic law includes not simply the statutory regimes, but also any other domestic law, and therefore encompasses common law.
But for our purposes, there isn't really anything that's otherwise so implemented, is there? Or
No.
Is there? No.
No, what's happened since, the TCA essentially brought in some people call a transitional regime for subsidy control, until such time as the Subsidy Control Act was enacted. And the Subsidy Control Act, I think, takes effect from 4th of January 2023, and therefore this covers the interim period. So the subsidy that was advanced in this case is in a transitional period from 1st of January 2021 through to 4th of January 2023. And we see then, please, at page 2164, paragraphs 228 to 230.
Sorry, I'm being slow. Just give me the date, subsidy. I know we got it somewhere.
4th of January 2023 is the Subsidy Control Act 2022 entry into force.
Yeah. So although the parties are referring to it in all sorts of indirect ways, the truth is, formally, it's an irrelevance.
Yes.
We just got to do our best with this rather odd way of...
The SCA had no retrospective effect.
No.
If we then please look at page 2164, His Lordship at 228 to 230, when dealing with the TCA, explains how relevant provisions that have to be given effect as a matter of international law are then incorporated into the domestic legal order. Please would the court read 228 to 230.
Yes.
And then 231 deals with the application of, in section 30 of the standard interpretive obligation under the Vienna Convention on the Law of the Treaties, requiring treaties to be interpreted in accordance with, in good faith and in accordance with their ordinary meaning. See the top of page 2165, paragraph 232.
But so far as relevant for our purposes, it is as if, although it's very inconvenient because it's not ordinary domestic drafting, it is as if the provisions of the TCA are part of an English statute.
Exactly.
But it is a very odd way, but because everyone knew it was odd, that's why they quickly tried to do some,
Well, it was
but not quickly enough.
It was a sticking plaster to deal with a temporal period where everything was, it's fair to say, somewhat chaotic.
Yes, right. Well, we've got to do our best with it, obviously.
So when Article 366 is transposed into English law, does it have the meaning that a subsidy can only be given, for example, if it is proportionate and the minimum necessary?
Yes.
Or does it mean that it can only be given if the Secretary of State or the granting authority determines that it is?
Well, as a matter of law, our submission is that because the operative provisions of the subsidy control provisions are directly incorporated into domestic UK law by Section 29, that is a hard-edged legal obligation that has to be met. Because that's what Section 29 says, as construed by Lord Justice Green in the Heathrow case. There is no prism of rationality for those obligations. And if I can suggest what a purposive construction would require, following Article 31 of the Vienna Convention on the Law of the Treaties, the purpose behind this was to put in place a transitional period of subsidy control that was effectively maintaining in place provisions that were common to the EU and to the UK, because they were both saying, as a result of this agreement, we want a level playing field. You don't have the recitals to the agreement, you haven't been burdened with those, but the recitals 8 and 9 to the treaty make it clear that it's trying to establish a level playing field to enable trade to carry on a free trade basis between two now sovereign blocks, one being the United Kingdom and the other being the EU as a bloc. And so in circumstances where the EU is saying to the UK, you can continue to have free trade with us on these parameters, it's clearly important that subsidy control is maintained on both sides of the fence. And we know that the EU has state aid provisions in place because we followed them for 43 years, 44 years, however long it was. We know that the UK was obliged by the TCA to put in place subsidy control measures that were effective and that guaranteed the terms on which subsidies would be given. And so this was a means of effectively maintaining an appropriate level of subsidy control that satisfied the EU that their new free trading partner, the UK, was doing its bit and was not unduly preferring UK companies to the detriment of EU companies. And if I were to give you a hypothetical situation in which a court in Germany is seized of a dispute about a German subsidy to a German electricity company, that German court will be applying EU state aid principles to that subsidy and will entertain a challenge by a UK company to the grant of the subsidy to the German company, provided that the UK company has standing before the German courts. And that will be a matter for the German constitution to recognise. So this court, we say, is discharging the parallel function that the EU court would be discharging in regulating the grant of a subsidy by one of its own to one of its own.
Even if the market is an entirely domestic market.
Yes, because, my lord, the market is extended. Well, the capacity to trade between two different markets has been freed up by the abolition of what would otherwise be tariff barriers or custom control checks or things such as that. So you end up in a position where the whole point of a free trade agreement is that goods can move freely between the two markets. And therefore, it is of the essence that both markets are subject to common controls if, for example, the grant of subsidy is considered to be anathema to a free and functioning market. If you want free markets on both sides of the fence, you have to have...
express provision.
Mr. Peretz has pointed out that E.ON is a German company.
Sorry?
Mr. Peretz has pointed out that his company is a German company.
Well, they are a German, yes, but the market is
the UK market.
The UK market.
It has a German parent of E.ON who is investing in the domestic electricity.
Well, I was wondering about that because the express phrase in the article, whatever it is it has to have, I forget the exact phrase, but it has to have an impact on trade or investment between the parties.
Perhaps if we could turn that up, my lord, because that's the next point of my note. So that's a convenient moment to...
yes.
It's Bundle of Authorities 8, tab 93, page 3680. That's Bundle of Authorities 8, tab 93, page 3680. I'm also reminded by Mr. Peretz that, of course, in the electricity context, you do have interconnectors between the UK and, I think, France and also the Netherlands. And those interconnector cables enable a common electricity area to allow supplies of electricity to move between different borders. But, I mean, that's a point of detail, I think, that need detains. Could we please go to the Article 363, which provides the definition of the subsidy, which is, I think, the stepping stone before we look at 366. So at the top of 3680, we see subsidy means financial assistance.
So sorry, again, you'll just have to get used to me. I'm rather slow. Which page?
Top of 3680, my lord.
3680, sorry.
3680.
Yep.
And would you be kind enough, please, to cast an eye down the definition of subsidy?
Yeah, well, my question was obviously largely about Little Roman 4.
Yes. And then, for good order, if we could look, please, briefly at the principles at page 3684, Article 366. That defines subsidy, and it sets out, with a view to ensuring that subsidies are not granted where they have or could have a material effect on trade or investment between the parties, each party, so that's both the UK and the EU, shall have in place and maintain an effective system of subsidy control that ensures, so it's an outcome obligation, ensures that the granting of a subsidy respects the following principles. And then we have subsidies pursue a specific public policy objective to remedy an identified market failure. They are proportionate and limited to what is necessary to achieve the objective. So, my Lord Justice Zacaroli's point, is that hardwired into what domestic law requires? Yes, it is, because it's there, and Section 29 brings it into the domestic law regime. These are outcome obligations. Every subsidy has to comply with these principles. C, to the extent they're designed to bring about a change in economic behaviour that is conducive to achieving the objective and would not be achieved in the absence of the subsidies being provided. So you need them, and they're going to bring about a change in behaviour so it doesn't happen again. D, they normally compensate for the costs the beneficiary would have funded in the absence of any subsidy. E, they're an appropriate policy instrument, cannot be achieved through other less distortive means. What does less distortive mean then? It means that you have the least possible interference with a domestic market, be that domestic market in UK or one of the member states. And so UK companies should not be disadvantaged in France or Germany by a subsidy given by the French or German government to one of their own. If a UK company thinks it has been at disadvantage because there's a less distortive means of achieving the objective of the subsidy granted by that foreign state, then they have a right to invoke the domestic law of that state to say you haven't followed the proper procedure.
As you will know, but therefore it's easy for me to confess, I'm not a competition lawyer, but are these provisions and principles, they weren't dreamt up for the first time for the purpose of the TCA. These would be familiar from are these lifted straight from the relevant EU legislation?
They broadly mirror the EU legislation. There are elements of the WTO framework as well. There is a WTO agreement on subsidies and countervailing measures, which has been agreed at international level through the auspices of the General Agreement on Tariffs and Trade. And that WTO agreement also provides, as we'll see from, for example, the British sugar case, can provide interpretive means of construing the TCA, and there's a provision in the TCA that says as much. I think it's 515. So the rather curious feature of the TCA is it was drafted by the UK and the EU, but with the EU not recognising that the UK is no longer a member state, but the EU is itself operating under the auspices of the WTO and GATT. It has a block booking, if I can put it that way, in the GATT WTO order. So the EU, through the Commission, acts on behalf of the member states who are member states of the EU. And so when you see WTO case law, it will often feature the EU as a member state party, a state party to that international convention. Obviously, once the UK is no longer part of the EU, it falls outside that pigeonhole of being part of the EU as part of the WTO overlay. And you have the UK and EU both recognising that they are subject themselves to WTO international law obligations. It isn't the WTO, however, that is brought into direct domestic effect. It's not a self-executing treaty, and we have the dualist approach to international treaties. So unless there is direct incorporation, such as you have with Section 29, the WTO provisions don't apply. So what does apply is the TCA. That's a convoluted way of saying this is a hybrid mixture, predominantly in this section, of what was EU law since 1973 for us, but also it has an overlay with the WTO. And we then see subparagraph 3 on page 3685. It's for each party to determine how its obligations under paragraphs 1 and 2 are implemented in the design of its subsidy control system in its own domestic law, provided that each party shall ensure that the obligations under 1 and 2 are implemented in its law in such a manner that the legality of an individual subsidy will be determined by its principles, by the principles. So again, that's reinforcing this isn't a matter for the discretion of either the EU or the UK as the state parties to this international agreement. It's imposing a hard-edged obligation subsidies granted pursuant to the TCA will comply with these principles. And
Again, we see in subpara 2 the same phrase, if the subsidies concerned have or could have a material effect on trade or investment between the parties.
yes,
If we were looking at EU legislation, would it be the same language but use phrase like member states?
for the internal EU legislation, it would be. In terms of implementing the TCA in its relationship with the UK, we would need to look at how the EU has sought to impose the obligation on member states to give effect to this particular obligation. And I confess I don't have
But it was the first I was asking.
legislation immediately to hand.
So is your point on 363 1B4 that any subsidy from the UK government to any entity which could have a distorting effect on the market is by definition something which is capable of acting to the detriment or having an effect on trade or investment between the EU and the UK?
Well, obviously, if one has a very local subsidy with, for example, a local authority in South Wales giving a grant of money to a local rugby club to help with a provision of a new wing of a new stadium, and there isn't a domestic builder who is based outside the UK who is tendering for that project, it would be quite difficult to see an effect on trade or investment between the parties. And that was one of the arguments in the British sugar case in the context of the Northern Ireland Protocol, the extent to which there was a sufficient impact on trade in Northern Ireland from the particular measure that the UK government introduced. Where we're dealing with the entirety of the electricity supply market, with a very substantial 4.5 billion subsidy given to one player in that market, in a market which is characterised by ownership from companies that are established in the EU, there is, we say, a sufficient effect on trade or investment for that threshold to be met.
But is the key word there investment? There's no trade.
Well, there is, my lord.
This is the interconnector.
This is the interconnector point. Yes, you can flow electricity between the two different electricity sub-markets. There is a common.
Subject to that, suppose that the electricity was all generated in the UK, and therefore nothing moved between the UK and the EU. Then your point would have to be about investment.
Yes.
That is to say that UK supply companies were owned by EU companies.
And I can give my lord an example of that. So since 2014, we've had a contracts for difference regime in the United Kingdom. This regime was brought in to help fund renewable electricity generation. So it was recognised that the capital costs of building wind farms were so substantial that the market prevailing electricity price was never going to lead to sufficient production. So the government introduced a subsidy auction through a contract for difference regime, which it notified to the European Commission, and which the European Commission said would not constitute unlawful state aid. That was challenged in a case called Tempest Energy, and the General Court said that the European Commission should have examined it more closely. The Commission appealed against that, and the Court of Justice on appeal overturned the General Court's decision. So the point remains that the European Commission was notified of the subsidy auction process, whereby a strike price is given above or below, it depends, but a sufficiently high strike price in a contract for difference is made available to a renewable energy producer so that they can rely upon that price to justify their investment decisions. And that led to a very substantial rollout of wind farm generation in this country. And that's an example of a subsidy being treated by the UK government as notifiable to the EU Commission. For what it's worth, and this isn't simply a pleading point, the Secretary of State has never suggested either that subsidy control principles don't apply or that the relevant criteria of the decision having a sufficient effect on trade or investment has not been met.
No.
But this is simply from
there
my
are going to be
lord's.
several points here, I think, where the parties agree that the law is X, but we just need to understand why.
Of course.
And you, I think, explained why. We had noticed this isn't a point taken on.
No,
Side.
no. Deliberately.
That's extremely helpful.
Doing
And
it
I'm not. Could you just, not asking for a hard copy, but just for my general education, could someone send us Tempest Energy, which I think isn't among the cases,
It's not.
but just so we can understand how it works? Yeah.
Yes, of course.
background.
I may be misremembering, but I
Asking
think
for
Mr.
submissions.
Perrotts was counsel in that case. I may have got that wrong. So he will be able to take you through the minutiae.
I think it most unlikely will be asking to be taken through the minutiae. It's useful background.
Yes, of course.
Yep.
So that then, by way of the lie of the land, is what we say, what constitutes a subsidy. The principles have to be met. And we say, with respect, it's for this court to ensure the UK meets its international treaty obligations precisely because Parliament has designated the courts as able to rule on those issues in accordance with the rule of law through Section 29. And we have
But of course, no procedure is provided for at all, not which court, operating which principles, other than same as you find in the TCA.
And in the TCA, there's an obligation to have an interested party that is separate from the person who's providing the subsidy, who is capable of reviewing that. And that is simply missing in what I've described as the transitional implementation of the TCA.
But that's not a point taken in this litigation.
It has been taken by us because what we say on the standard of review point, ground 2 when I get to it, is if you look at the Subsidy Control Act 2022, the Competition and Markets Authority has been designated as the authority that provides an advisory piece when there is a significant subsidy, a subsidy of particular interest. And so we have now an established line of advices from the CMA that encourage public bodies to make better decisions on the grants of subsidy. And we can provide the court with an example of that if the court would like to see one. There's one, for example, for the latest round, the 6th round of what I've described as the contracts for difference regime, where the subsidy advice unit of the CMA gave advice to central government on how it could better implement the allocation of subsidy for renewable generation going forward. And we can provide the court with an example of that if it would be of assistance. But the point I'm making is that there is no equivalent to the CMA in the transitional regime because the UK, this is not necessarily criticism, it was a chaotic period and they had to apply a sticking plaster to a sudden drop-off of the applicable law that had been EU law until the 1st of January 2021. But there was no interested party put in place. Independent authority, sorry. So the idea is you have an independent authority that is kicking the tyres on the subsidy with a view to ensuring that it's not the government marking its own homework. And we don't have that. And
That's not relied on as a ground of unlawfulness of these decisions.
No, not in and of itself. What we say that goes to is the standard of review, because this court, therefore, is to use an overly worn phrase now, it's the only show in town in terms of marking the legality of the subsidy that's been given. And we say, post-Brexit, it's not simply a question of the rule of law giving effect to the UK's international obligations. This matters for the purposes of competition as well. Subsidy control, as state aid before it, is, as my lords rightly pointed out, an adjunct of competition law. Why does it matter? Well, because the government should not, in principle, disrupt a freely competitive market by making substantial taxpayers' money available to one party over and above the money identified to other parties. So you don't pick winners and you don't give a perceived winner substantial funds. Now, of course, we recognise here that Bulb's collapse was an example of market failure. And so the initial intervention with Bulb is not the subject of any criticism or complaint. We haven't challenged the grant of the rescue subsidy, but it's the transition from that rescue subsidy, enabling Bulb to be carried on so that the customers can carry on receiving electricity supplies, gas supplies from Bulb. It's the transition from that to deciding who is going to run Bulb going forward that is at the heart of this appeal. And here we move from rescue subsidy to restructuring subsidy. That was recognised in the government's own assessment. And the restructuring subsidy was over £3 billion. To give you an example of how big that is, the first 3 allocation rounds, I think, of the contract for difference regime amounted to £3 billion in total. The 5th allocation round, which didn't do so well, was £5 billion. And there were subsidy auctions required for each of those by central government to ensure that there was an open, non-discriminatory competitive process for the grant of the subsidy itself. Here we simply say the government did not follow subsidy control principles when granting the subsidy. It moved from a private sale scenario with administrators trying to find the best buyer to an inevitable recognition that substantial government funding north of £3 billion was going to be on the table in a way that was non-transparent, discriminatory, and didn't therefore produce the competitive outcome that was required.
You said earlier that an advantage of, even if you don't get a recovery order, is to make the point that the government must be more careful in its subsidy decisions in similar situations. From what you're explaining to us now, this particular situation is unlikely to arise in this form because we now have, the sticking plaster has been removed and there's, how the metaphor goes on, the wound has been healed by the 2022 Act. And CMA now has a role which it didn't have before, it's giving guidance, da-da-da-da-da. This is historical only, isn't it?
Well, my lord, no, because the natural inference when one looks at the Subsidy Control Act 2022 is that whatever the learning that derives from my lord's judgment in due course on, for example, the standard of review, for example, on what the subsidy control principles mean, to what extent is it for the court or for the executive to make the initial decision as to whether the principles have been complied with, that is something that is going to run right through the issue of the Subsidy Control Act principles, because there's a Schedule 1...
We do that by looking at the Act.
But the Act
we're not allowed to do for this purpose.
But the Act makes it clear that this court, reviewing a subsidy decision under the 2022 Act, will apply judicial review principles. This is a judicial review applying those subsidy control principles, and the subsidy control principles are scheduled out. They're enumerated in Schedule 1 to the SCA 2022.
Yes, but you say the important question that will be answered by these proceedings has already been answered by the 2022 Act.
No, my lord,
I'm misunderstanding you.
All that the SCA 2022 says is that the court, when reviewing a subsidy, will apply judicial review principles. That leaves open the question of whether or not judicial review principles require the subsidy control principles to be treated as a hard-edged legal obligation, which is our submission, or whether they have some facet of rationality so that one looks at it through the prism of, was the Secretary of State's appreciation of what the subsidy control
principles... Yes, but that will have to be decided squarely by reference to the 2022 Act and what it meant. How is it relevant what the position was under the previous treaty? I imagine you will say, well, other things being equal, you should be expected to be complying with international law, namely the TCA, which, and here's an earlier decision of this court, us, saying what the position is under the TCA. Is that why it's likely to be relevant?
Well, it's relevant for the specific case before my lords for that reason. Namely, what matters is, was there an error of law in the implementation of Section 29 and through Section 29 of the subsidy control principles found in Article 366? That's a hard-edged legal question, we say, for this court to resolve, and it matters for this case. My lord's point, I thought, to me was, well, does this make any practical difference at the end of the day? To which my answer to my lord is, yes, because the Subsidy Control Act sets out and replicates the subsidy control principles that you see in 366. So instead of having to rely on Section 29, what we now rely on is Schedule 1 to
yes, so you're saying a decision by us on our international law obligation, well, they are actually, will be effectively decide the position under the 2022 Act as well.
Section 29 basically was the mechanism of implementation of those principles until the 4th of January 2023. After the 4th of January 2023, Schedule 1 to the 22 Act does exactly the same thing.
Okay, well, I see how you put it.
So that, we say, in terms of ensuring a level playing field in a highly competitive market, it's very important, we say, the government follows the subsidy control principles as it's required to do as a matter of law. Now, the first public announcement of the subsidy here was given on the 21st of December 2022. By public, I mean the specific terms of the subsidy, other than disclosure to the parties in this litigation. My lords will see that in Supplemental Bundle tab 71, page 807.
Supplemental 1, 807.
Tab 71, page 807. It should be, I think, in the third volume. So whilst my client and the other claimants below were given some disclosure on the 23rd of November 2022, this was the first record on the new public subsidy database that the government had set up in order to give effect to its TCA obligations. This is the first record of the subsidy that had been given. Published, as we see, at 807 on the 21st of December 2022, so after almost a month after the claims had been started. And then at 809, my lords will see the way that the government is summarising the funding facility and what's been done. So second paragraph down, it said there has been run an open and competitive sale process. Secondly, next paragraph down, government will assist in providing support to a new and separate entity owned by Octopus. That's government support being provided. And then for the rest of the page from halfway down, details that funding is given. Could I please invite the court to read the rest of that page?
So how much you asked us to read?
To the bottom, please.
Yes.
And then on top of the next page, the JEAs had estimated that the new post-completion funding facility has an upper value of £4.5 billion. 4 or 5 paragraphs down in the centre of the page, it says the 4.5 billion figure represents an estimated upper limit of the support based on forecasted energy costs during the period until 31st of March 2023. And that reflects the current volatility in global energy prices. The extent of the government support could be lower than 4.5 billion, depending on the energy prices this winter. Of course, the volatility means it could have been higher as well, but that was estimated to be the upper reach. Now, in terms of the specifics of what was given, my lords will have seen the individual components in the judgment itself. So if you'd be kind enough, please, to turn to Core Bundle, tab 7, page 125, which is the judgment. And paragraphs 96 to 97. Please could I invite you to cast a further eye over 96 to 97 to see the individual components of the subsidy that was given.
To the end of 97.
Yes, please. In a nutshell, you have a grant of a very substantial provision of funds under the WAMA, the Wholesale Adjustment Mechanism Agreement. That enabled Hiveco, the new company, to buy energy in the wholesale markets, even though it hadn't hedged. It would only have to repay a lower sum on the assumption that the price that could have been obtained had it obtained a proper hedge consistent with the Ofgem price cap. So it received billions of pounds of support for free, paying nothing up front essentially for energy costs until the 1st of April 2023.
So the 4.5 billion is the estimated upper limit
Yes.
of what would have to be repaid, assuming energy prices remained high.
But from the 1st of April 2023, they would have started paying ordinary wholesale prices.
Yes, for this 6-month period. But that's just an estimate.
That's an estimate.
As it turned out, energy prices were much lower.
Yes.
So as I understand it, this worked to the government's advantage, not Bulb's advantage on this particular hedging aspect.
It turns out, whether it's fortuitously or not, there was no way of knowing this in advance, and the Divisional Court found that the hedge was not a hedge that would have been available in the market.
Yeah.
But it turns out, somewhat fortuitously, that the government is probably in the money on the hedge, but we don't know.
Right.
Now, there's been some correspondence on this. We, I'm afraid, don't accept that all of the money has been repaid and then some, but we're not in a position, I'm afraid, there's simply no evidence before the court for a proper appraisal of that to be made. Our suggestion is that the analysis of how much money has been obtained and should be repaid is a matter for the recovery procedure when proper evidence can be given to the court on remittal.
But assuming it has all been repaid, so that 4.5 billion figure is actually zero.
Well, it's turned out to be zero.
Assuming it is.
Yes.
You would say that this hedge arrangement, or however you define it, had a value to Bulb at the time,
yes,
for Octopus, and the value is essentially what it would have costed in the market to obtain an equivalent pay.
My lord, that's absolutely how we would put it. My learned friend Mr. Perrotts is reminding me that it's similar to a guarantee. You can't get a guarantee in the market and the government gives you one, that has a value. Now, working out that value is not necessarily very easy, but that is, with respect, not for today. The second element was the stub price cap, which enabled effectively a sum of money to be given to Hiveco to assume that completion would have taken place earlier, and it essentially provided working capital support. There's then the interest provisions, which on any view were not commercial, and the Divisional Court found that they weren't commercial. Interest is only payable in certain circumstances, and even then only at 2%. You've got the regulatory change protection, which has a value, and then you have the separate equity injection. So Bulb was given money in order to inject into Hiveco so that the purchase price for Bulb comes to a figure of £1. So that neutralises. Everyone at the time realised that Bulb had a massive unhedged wholesale position and was losing money. And in a nutshell, the reason it was losing money was because it had committed to energy supply contracts, which were subject to the Ofgem cap and or were fixed with the consumer. So it was only receiving a set income. And because it hadn't hedged the wholesale costs, it was suddenly having to pay more for the wholesale supply of electricity than it was getting in at the retail level. So it was losing money on each contract. And there was no disguising that. So that the Bulb value on a rational economic sense was zero. To overcome that, we had this equity injection paid by Bulb to Hiveco to bring the value of the company to zero, or effectively to £1 for effective consideration. Separate from that, Octopus put in a separate equity injection from the buyer equity injection perspective for Hiveco, which was based on its assessment of what the value of that equity was. And we say that was itself a subsidy to Octopus for the separate reason that the value of the equity injection was not determined by an open, non-discriminatory and competitive process. So those are the different elements of it. It is very substantial. And therefore we say it's particularly important that the subsidy control principles were followed with rigour. And the reason it needs to be followed with rigour was to ensure that the level of the subsidy paid was kept to the absolute minimum necessary. I.e., if you're going to intervene in this freely competitive market, what's the minimum the successor company, the company that's rising like a phoenix from the ashes, what's the minimum that company needs to carry on doing the job? The minimum it needs, not for the job itself as a commercial perspective, the minimum it needs from the taxpayer to enable it to carry on doing the job that it wants to do, i.e. supplying customers. And that should have been, we say, the focus of the analysis. And with the greatest respect, we say that the process that was followed did not meet that. Now, the consequence of this subsidy were very substantial. So Octopus's website, if one glances at it, says that it's acquired nearly 2 million customers since January 2023. It's a fact from the Divisional Court judgment that it overnight acquired 1.5 million customers through this transaction. And this is at a point when, because of the off-gem price cap, switching in the market was virtually unheard of because everyone was pricing at or around the cap. So whereas you'd had a very active switching market in the decade or so previously to the off-gem price cap, suddenly because of wholesale prices going up and electricity prices being capped by off-gem and a regulatory decision, everyone was pricing at the cap. And so the prospect for one customer switching from one company to another diminished rapidly. Now, as a matter of fact, Octopus's market share has doubled since the contested decision. That's only been possible, we say, because of the very substantial leg up it got from the government's subsidy. And that has changed the structure of the domestic supply market. Octopus was able to succeed in its bid after it received reassurances as the level of government support that we simply say were not made available to other market participants on the same equivalent basis. It was told, for example, that government was being lied up to provide substantial support, and that support would be delivered. Now, in substance, once one gets past delay and standing review, what lies at the heart of this case is this schism that the government brought in through the process. And that schism was, you've got a private sale that starts off being run by the JEAs on behalf of Bulb, using Lazard as market advisors. And that is intended to be a private sale by administrators of an insolvent company to another private company. And that naturally has to comply with all of the energy administration requirements that come from the Energy Acts. That's separate, we say, from a process at which it becomes inevitable that a transaction is not going to get over the line without a very substantial amount of government intervention. And once it's abundantly clear that government is going to have to give the sorts of level of support that we've seen, the process changes. It's no longer a private sale. It's now about finding the minimum subsidy necessary to give effect to a transaction.
It's apparent from the start, just reading the account in the judgment, that there would have to be everybody appreciated on the government side, everybody appreciated in the market. There would have to be government intervention of some sort. There were tactical reasons for not stating that openly, but it was understood by everybody.
Well, I think everyone understood that Bulb had a negative value. And you'll see when I come on to deal with the chronology of ground three of what happened when. There was an attempt at a private sale by Bulb management in November 2021, where my client, British Gas, put in a bid. And that bid was put in on the assumption that the company that they were buying would be debt-free and the issue of hedging would have been resolved, i.e. they were buying a blank company without any of the incumbency, the difficulties that went with the state of Bulb at that stage. And they valued it on that basis. Now, what then happened was management failed to secure a sale in time, and so it moved to this private sale process. But the problem is, my lord's absolutely right, it was apparent to everyone that there was a negative value for Bulb. But, and we'll see this in the judgment when I turn to it, and indeed in some of the supporting documents that I will turn to only ever so lightly, we will see that the government was telling the energy administrators and Lazard, you can't tell the market that we're going to step in and provide funding. You can't lead the market. That was what they were told. And with the greatest respect, doing that at phase one, not a great idea because nobody actually is going to put forward a sensible bid, which is what happened. Suddenly changing the parameters at phase two and saying, actually, you can go forward with certain people and tell them that government funding will be available, but we're not going to tell you how much or what they should bid for or what the parameters of government funding are. Completely changes the dynamic. It moves it from a private sale, which is essentially doomed to failure, with grace and respect for the reasons my lords just articulated. It moves it from a private sale that is never going to get anywhere to a subsidy auction process where the parties, in order to compete on a level playing field, ought to be told in terms, this is the parameter of the government help that is available. And that's what's been done in the contract for difference market. And it's also been what's been done with subsidies given through the capacity mechanism provided for the UK electricity market, where again the UK recognised it didn't have enough electricity production and provided a subsidy on an open auction basis to companies who were prepared to commit to developing electricity generation on the back of a clear subsidy strategy that the government rolled out. Now, we say that schism in control. Essentially, the government decided to leave it to the JEAs to run a private sales process, whereas it should have been saying, but there's a significant subsidy control principle overlay here. You can't simply run this as a private sale. You need to run this as a subsidy auction. But the JEAs were doing their own thing. We make no criticism of the JEAs for running a private sale. The point is, it was the responsibility of the government to put the subsidy control overlay on top of that framework and ensure that the principles were being met. So it's true that, for example, possibilities of achieving a private sale were inauspicious. But of course, that then prompted Lazards and the JEAs to advise the government that they really ought to be more forthcoming about the availability of government support. It was putting off bidders. That was the expression that was used. But the JEAs, and this is where the schism comes between control and responsibility. Responsibility for complying with subsidy control principles is on the Secretary of State. It's not on the JEAs. The JEAs were doing a different job under the ESC of finding the best sales price for a private company. That was their only job. If we look, please, in Supplemental Bundle 10, page 314. This is part of the Bundle 1, Supplemental Bundle Tab 10, page 314.
Is this?
This is
Mr. Cowlishaw's witness.
Mr. Cowlishaw's third witness statement. He is one of the Joint Energy Administrators. Please would the court read paragraphs 95 and 96. And what we say, my lords, that amounts to is a recognition, quite rightly, by the Joint Energy Administrators, that it wasn't their job to be doing the subsidy control exercise. And we respectfully agree. That was the job of the Secretary of State. And interestingly, when we see the advice that is being given, if we could turn, please, in Supplemental Bundle tab 33.
Well, just before you move on from this, B on 96, they say they made available equivalent information, including where considered relevant regarding financial support to bidders who had proceeded to an equivalent stage. Do you see that's wrong?
Yes.
Wrong as a matter of fact.
Wrong as a matter of fact. Demonstrably wrong as a matter of evidence that was before the Divisional Court.
In what respect?
Well, the Divisional Court found that, I think this is paragraph 6, they found that inevitably different things were said to different people.
Well, but the important point in that paragraph was to bidders who had proceeded to an equivalent stage. Is that wrong?
Yes, because, for example, Tulip, who was one of the bidders in phase 2, was told different things to British Gas. British Gas was not told, and I'll take you to this in a moment, was not told what was made clear to Octopus. So demonstrably, on the face of the documents that I will show this court, not everyone was told the same thing.
At the point in time that British Gas was still a bidder who had proceeded to an equivalent stage.
At the point in time of phase 2, when British Gas was still part of the process. British Gas was involved up to and including end of July, beginning of August, when it was involved in discussions with the Secretary of State. There was a text exchange on 10th of June, which the Divisional Court has found marks the death knell in British Gas's participation. But in fact, their participation continued after that. But with the greatest respect, it doesn't matter whether or not British Gas or E.ON or anyone else were told this, that, or the other. I will, as a matter of fact, establish that they were told different things. But the point is, everyone should have been given transparently the same information. And they weren't. There was an ad hoc process instead adopted by the JEAs because they weren't seeking, well, JEA stroke Lazard, because they weren't seeking to establish a subsidy auction. That isn't what they were doing. So if we could go, please, to Supplemental Bundle tab 33, page 566.
Sorry, page.
566.
Of which bundle?
So that is going to be in the third bundle number. Tab 33, page 566. Now, parts of this are protected by confidentiality, but it's fair to say it's an email from the government to the Joint Energy Administrators, and otherwise it makes no sense. And at the top of page 566, one sees an email dated 29th of March 2022. As discussed yesterday, I'm coming back with our collective response to the Q&A Pact. This is the government saying, whilst we do appreciate that some version of the support outlined in the financial structures paper is almost certainly going to be needed to support a transaction, we still feel there's a separate decision regarding the timing at which this is confirmed to bidders.
Sorry, just remind me who this is. This is actually, yes.
This is
no, I can see who it's from, yeah.
This is from the department to Teneo, the JEAs. Our understanding had been that you would limit any acknowledgement of potential support during phase 1 and then engage more openly during phase 2. And then there's a series of points. Halfway down the page, there's a separate marked paragraph 2. We're particularly uncomfortable in relation to the following sentence. The administrators have had preliminary discussions with the department or His Majesty's Treasury on potential options in relation to this aspect of a potential transaction and can share feedback as part of this call. We're nervous about commitment to providing HMG feedback, as so far we've only provided you with very informal steers. So the government is saying to the administrators, please don't mention government support at phase 1. What we will do at phase 2 is engage more openly. But that, with the greatest respect, is not an open, transparent procedure. Now, by the start of phase 2, it was readily apparent to Lazard that the government would have to provide clarity if they were going to get any sensible bids. And we can see that, tab 36.
Sorry, just remind me, I feel I know, but I haven't quite pinned down. What is the formal distinction between phase 1 and phase 2? What indicates when you've moved from one to the other?
Phase 2, you're invited to provide a non-binding offer for the purchase of all or part of the company. And to come forward with a structure for the transaction. At tab 36 of this bundle, page 580, bottom right-hand corner, this is a briefing paper executive summary prepared by Lazard, I think, from memory. Yes, it's Lazard, bottom left-hand corner. Bottom right-hand corner, page 580. in order to achieve a sale, HMG will be required to provide clarity on the measures it will take to provide bidders with comfort around the uncertainty surrounding future losses and associated capital working requirements. And that was based on an analysis of phase one's bids, which one can then see going over the page. There's a series of people identified, 19 parties in phase one, and then the current status of those parties is identified. Turning to page 582, in terms of engagement, Lazard says serious engagement required with the department to define how to make bulb an investable opportunity. Have to identify the market communications that can be used.
So where are you reading from now?
The second row down under engagement with
But on which
base
page?
and off-gen, page 582.
Yes, thank you. Yep.
And then under that second row, engagement, second indent, define in detail and propose transaction structures or de-risking mechanisms that can be explored with remaining bidders. So that's Lazard saying, look, you've got to encourage these people to come forward with investable options, investable bids. And that means you've got to come off the fence about government funding. Top of page 583. They summarise the key areas of uncertainty to be addressed to enable a transaction. So the point that's being made is the point my lord has made. Everyone knew this is a negative value company. It's not going to get across the line without government funding. But you, the government, says Lazard, you need to come off the fence and say what's going to be available. Then says hedging and forward price volatility in the context of the price cap limitation, transaction structures or mechanisms to mitigate the significant value uncertainty. And what is required is a risk transfer to government of any negative value impact from executing the forward hedge versus the assumed hedge, given low market liquidity and high price volatility. Potential support for significant collateral requirement. And that's what we ended up with. That's what ended up happening through the ad hoc process that I'm about to describe.
May I just ask one question on subsidy control and fair and transparency? If everyone knows that this company is effectively insolvent, if everyone knows that you've got to deal with the switches that have already been agreed, as you identified in your earlier bid for the company, is it a fair and transparent process if you all know there's going to be some government support, you tell us what you need, and we're going to give you as little as we can get away with? Or is that not fair and transparent? Do you actually have to say, here's $4.5 billion, all of you bid for it?
What the government has to say is that the government is prepared to cure the market uncertainty and ensure that there is a transactable bid. Now, it would be required to say, in my respectful submission, that government funding would be available to deal with the hedging issue, and government funding would be available to wipe off any existing debt in the company. Nobody is going to buy for more than £1 a company that has any debt, because it has no value. So if the net assets versus liabilities is negative, and if the future income stream is negative, nobody's going to buy it. And what you need is a commitment from government that says, we will make this a transactable opportunity, the Lazard wording, we will make this a transaction that's capable of being done by ensuring that everyone starts off on the same base level of debt being wiped out and hedging being dealt with. And that's what the government never put into words, at least with us.
So you say the two key things that have to be told to all potential players in the market are that government will cover the wiping out of the debt, and what was the second element?
Providing a resolution to the hedging issue. So the company was unhedged, and it was unhedged for that significant winter period. And the wholesale prices were going to be a problem in the next 6 months because of that lack of hedging. If you could trade through that and get to the summer months, market conditions would change and you might then be able to do something different. But unless everyone knows that there's a level playing field on exactly what the true value of the company is, everyone's second guessing what government support might or might not be available. And that's what happened. You have people going
Why
in.
can't they say, well, this will be our offer, and our offer will, a term of our offer will be that the government will cover those 2 points?
Yes.
Well, they could say that. What's stopping them saying that?
But that's what they should have said, and they didn't.
No, so why can't the parties say that?
Well, Octopus went in, having received the reassurance that government would be delivered, making exactly that offer. The point is, everyone else didn't think that the government was going to provide that level of support. I can show you this most
Why
clearly.
didn't they make an offer saying this is our offer, which includes a requirement that government will give on that level of support?
Tulip, for example, when they pulled out, said in terms, we don't think this will work without government funding, and we've seen no indication that government funding is available. After they had withdrawn from the phase 2 procedure, they were then said, oh no, government funding can be made available in principle. And they then were given the opportunity to put in place a structure that was effectively offered by Octopus. And they were given the opportunity to engage on that basis.
Who are they for these purposes?
Tulip. I'm using a code name that was given to
I understand that. I know.
So
The Tulip were given
they were.
equal treatment.
Well, they were given a stronger steer, actually, that government support was potentially available because they were given a specific mechanism by which the hedging issue could be resolved. And it was offered to them not idly, but on the basis, have you thought about whether this transaction will work? So,
Yes. So your case is that it's not just that Octopus got this preferential treatment. Tulip did too, though for their own reasons they didn't take advantage of it.
yes.
But you weren't.
British Gas wasn't. E.ON wasn't, because E.ON by this stage was out, and they weren't one of the strategic buyers considered by Lazard to be worth reapproaching for the purposes of phase 2. Any number of market suppliers who I haven't mentioned also weren't approached and given this information. And so we're in a position where you have an ad hoc re-engagement process at phase 2, where Lazard approach people they think are strategic buyers, but with no real firm indication of on what basis those people were being approached. So Lazard's advice is you need to be upfront and open with everyone about the availability of government funding to cure the 2 insurmountable problems with this transaction. Government ignored that advice. They then gave Lazard permission selectively to engage certain bidders only on terms which the Divisional Court said somewhat elliptically in paragraph 59 of its judgment were not entirely clear. It's entirely unclear with respect to how Lazard chose to engage with 4 or so, 5 people out of the 17, 19, however many bidders it was who had engaged at phase 1. They didn't approach E.ON, for example, one of the appellants before you, who are a significant market player. And what followed, I'm afraid, was a non-transparent process. Now, if we can look, please, at the specific information that was given to first Octopus and then Tulip. Octopus, please, in this 3rd volume supplemental bundle, tab 38, page 601. This is an email from Mr. Quantock of KPMG to various personnel in the Octopus Group, including the Chief Executive Officer, Mr. Jackson.
Sorry, can you give that reference again?
Page 601. I think I've called him Chief Executive Officer. He may be Chief Financial Officer. Stuart Jackson. Nobody's shouting at me. So, please could I invite the court to read that email in its entirety.
Sorry. Oh, I see. Yes.
So Octopus was told in terms that offers above 0 would be progressed to phase 2. I invite my lords to bear in mind that Octopus at this stage had withdrawn because they thought this was non-transactable.
This is Mr.
He's the chief financial officer of Octopus.
Sorry, the email is from
It's-
KPMG.
It's from it's from a KPMG advisor
who
who
advised
Octopus had brought on to help them with this.
Relaying the contents of a discussion and exchange with whom?
Ms. Kotseva of Lazard. So he's had a conversation with Lazard and been told offers over £0 would get to the next phase. They'd pulled out of phase one, they'd withdrawn from the process. They were then brought back in with the suggestion that offers over £0 would get to the next phase. This ignores working cap. So offers over zero without taking into account working capital. So
Didn't the Divisional Court make some findings about what happened here?
they did. They did. The Quantock email is dealt with. Page 112, specifically subparagraph Roman 10 or paragraph 61. Now, this is
Sorry, where was this in the judgment?
it's page 112.
Oh, page 112. Sorry, I said paragraph.
Subparagraph Roman 10, where they summarise the email. With the greatest respect, the email speaks for itself.
Well, but they make findings at 62 about that, don't they?
At 62, they also say there was no witness statement from Ms. Kotseva and no explanation as to why statement was provided. They then make a series of evaluations following on from the primary evidence as to what inferences, if any, are to be drawn from this. And we, with respect, part company with the Divisional Court on its analysis, because the email is, we respectfully suggest, clear what its import is, namely that government will be delivered. You don't have to worry about working capital. Make an offer above zero and you get to the next phase. Have you thought about this, says Mr. Quantock? Have you got Treasury involved? Don't worry, government will be delivered. Now, the various objections to this email that are taken.
Could you read paragraph 63?
Paragraph 63, my learned friend invites the court to read, and no doubt the court will cast an eye over that now. With the greatest
Give us a moment. Yes, I mean, the underlying point behind the Lord's intervention is, even though this was a paper-only hearing, it's nevertheless the case that findings of fact about what happened are not normally reviewable here. And it's perhaps not, it's dangerous for us to go to an email, the effect of which is contested, without seeing what they found about it.
Well, my Lord, I absolutely accept that as a proposition. This is not a finding of primary fact. This is an inference drawn from a document, and I've taken the court to the document.
Well, there are issues. This is KPMG saying what they were told by Lazard.
Yes.
And it has been said by Lazard's, we didn't tell you this.
Well,
Or it's being said by Mr. Cowlishaw
Yes.
that Lazard's didn't tell you this.
we had nothing from Ms. Kotseva herself, and of
Now,
course,
I understand that, but still, so the point is it's contested.
well,
Whether this is actually what Ms. Kotseva said.
Mr. Cowlishaw's not in a position to vouchsafe one end of a conversation or the other end of a conversation that he wasn't party to. Ms. Kotseva was...
So you're saying this is a finding that it was not open to the Divisional Court to make in law?
I'm saying it's demonstrably wrong that the explanation that is given for this email by the Divisional Court it doesn't bear the meaning it does.
Exactly.
On any view, with the greatest respect, the Divisional Court has tried to say, well, it can't have had any effect, for example, because it came in after they'd already said that they were interested in proceeding to the next stage. Well, this is given 3 days before they submit the final bid that they did submit. On any view, British Gas was not told that if they submitted a bid that was over zero, they could get into the next phase. It's not being suggested by these findings, my lord, that this wasn't said. What's being suggested by these findings is that it didn't bear the consequences that we've sought to attribute to. Now, there's then an evaluation that the uncontestable propositions that are here are not materially different from what British Gas or E.ON were told. And that's an evaluation. And our point, and where we are entitled, with the greatest respect, to challenge the Divisional Court's conclusion, is where that is demonstrably wrong. But there is no evidence whatsoever that we were given this information that government would be delivered. What we were told was that there was a possible scope for discussing with government what might be needed. But nothing was said about working capital, and nothing was said that government would be delivered. So we're not in a position where we have been told what Bulb was told.
And just for my note, your evidence about your end of the understanding there, can you witness evidence?
Well, British Gas gave evidence as to what they had been told and what they had not been told by Lazard, and that's in Mr. O'Shea's witness statements.
Yeah, that was just the reference I wanted. So Mr. O'Shea's witness statement.
And I'll come on when I deal with ground 3 now later this afternoon with the tulip point. I don't want to. I'm afraid I've probably strayed longer than I should have done in my introductory opening. So I'm going to have to move on to delay because time marches on. But I will come back to the tulip point and show you the emails on the tulip points, where there are no equivalent findings that cast doubt on what is said in the emails. Unless my lords would like me to go to that now for completeness while it's fresh.
I think it's up to you, really. If it does fit in here, I suppose I would do it now. Yes, but you choose.
So in terms of tulip, please could we look at, they had made a non-binding offer, that's vouchsafed by paragraph 70 of the judgment. They then pulled out. If we look at page 70 of the judgment, paragraph 70, which is page 116, subparagraph 4. Sorry, starting with subparagraph Roman 1, paragraph 70. On 6th of May, Teneo held a call with Tulip to discuss the transaction in which forward purchases potential funding was raised by Tulip, and Teneo said that they would need to see something in writing, had to do some thinking, needed to understand what Tulip's thinking was. Subparagraph Roman 4. On the 16th of June, Tulip contacted Lazard to inform them that following extensive work and review as well as discussions with our stakeholders, we have concluded that an investment in Bulb is not in Tulip's best interest at this time. They pointed to, understandably, the risks of the wholesale energy market, and we believe that an ongoing HMRC participation in the business is likely to be essential to help the business through the short to medium term uncertainty. We then see, top of the next page, Lazard responded 40 minutes later, stating that many of the issues you've identified can be mitigated. You raise a point about government participation. Lazard stated it wanted to explore if a period of joint ownership could mitigate the collateral requirement and other issues you've identified. Now, when I spoke earlier, I said there wasn't really any gainsaying this as a proposition of what was said. The way that the Divisional Court, to be fair to it, had dealt with this was to say we don't quite understand what was meant by joint ownership and what that was intended to refer to. So I misspoke to that extent, I'm sorry. Subparagraph Roman 7, please, page 117. Lazard sent a further email to Tulip on 28th of June, offering a possible arrangement to resolve working capital and hedge collateral issues, effectively a guaranteed wholesale price, which would remove the need for a hedge. Now, it's that email to which I wish to turn, please. And that is at Supplemental Bundle, tab 41, so this volume 3. It starts at page 609, but as always with emails, we need to work back. And we see at the bottom, please, of page 610.
Give me a moment.
bottom of 610, I'm writing to inform you that following extensive work, Tulip has concluded that investment in Bulb is not in Tulip's best interests. Next, email up, halfway up that page, is the response from Luba Kotseva of Lazard, and she refers to the period of joint ownership, which the Divisional Court said they didn't quite understand what was meant by that. The follow-up email then starts at the bottom, please, of page 609 and ends a third of the way down on 610. Please, would my lords read that?
Sorry, it should be clear to me what SAR is, but
Special administrative regime.
oh, of course, yes, sorry. Yep.
Now, for completeness, I do need to take you, I think, to paragraph 71 of the Divisional Court's judgment. On any view, that is setting out a specific and bespoke form of funding that will be made available by HMG to cure the recognised problems. And the Divisional Court's response to that email, paragraph 71, page 117, was effectively to say that Lazard was entitled to reach the view that British Gas and Scottish Power had closed the door. Therefore, Tulip and Octopus were the only two parties left, and that essentially what is being suggested to Tulip is a replication of the structure that was already being advanced by Octopus, codenamed Orchid, during this process, and that there was a risk of Octopus pulling out if their structure of financing was essentially shared with market rivals. Now, the court's conclusion is not that this satisfies the subsidy control principles of a non-discriminatory and transparent process for selecting the level of government funding that is the minimum necessary. The Divisional Court's conclusion is that this is a reasonable approach for Lazard to take in the context of a private sale. And therein, my lords, lies the rub. Lazard is not thinking that it's applying the subsidy control principles, nor are the JEAs. Lazard has given advice repeatedly. You, the government, need to come off the fence and be clear about what funding is available. You need to deal with the problems that the market is recognising. And the government resists that. It's worried that it will be seen as opening a chequebook that can't be closed. The reality is, a subsidy was going to be necessary. And the proper lawful way of dealing with that recognition was to be transparent and open about the contours of the government funding. I'm not saying the government needed to say we are going to commit to £4.5 billion. The government needed to be clear that it would, in conversations with bidders, come up with a solution for the two aspects of the bulb arrangements which were making a sale untransactable. And that's no different from any other subsidy granted in any other context.
So I just want to get that straight. The minimum the government has to do is to be clear that it would work with
bidders to solve
bidders to, what was your phrase?
Solve the two unsurmountable problems that have been identified, namely absence of hedging, specifically for the winter period, and the existence of very substantial company debts. Those are the two things that are driving a negative value for this company.
They didn't have to put forward any particular commitment, just say well willing to look at these with you.
Well, the government has to say that it will solve those problems in a process of providing government funding, and then the amount of government funding that will be required will be calibrated by reference to individual bids that put a pitch in for how much will be needed. And so I can give you a very obvious example of what rival bids might look like. If you've got a heavily capitalised company like British Gas, which has got billions of pounds worth of assets on its books, it doesn't need to go to the market to get working capital to fund wholesale purchase transactions. If you've got a thinly capitalised company that's a new entrant to the market, it does. And the cost of going to the market to get the capitalisation required is going to be higher for a thinly capitalised company than it is for a heavily capitalised company like British Gas. And that commercial, economic situation will produce a different need for resources from central government. And unless you do this open, transparent procedure that I'm urging upon the court to recognise is a lawful one, you just don't know what people might have said was the maximum amount of government subsidy that was necessary. And instead of going to the market on an open basis saying, look, we recognise we're going to have to fund this, tell us how much you need to fund this to get it off the ground, the government played this rather elaborate cat and mouse game with bidders saying, give us your best bid, and then telling other people, here's some information that will help you get the reassurance you need in order to put in a bid. And whereas Tulip and Octopus got told specifics about the availability of government funding and it being delivered and it curing the working capital problem, British Gas, E.ON, other players in the market didn't get given that opportunity. And that, in a nutshell, is the substantive case.
You mentioned a few times that the government here failed to comply with the subsidy control principles. I assume at some point you're going to develop what those principles are.
That joy falls to Mr. Perrott.
For example, which doesn't appear in the principles itself. You'll tell us, you'll join the dots at some point.
Mr. Perrott, when I finally shut up, my lord, will be dealing with that point. That, I'm afraid, was rather an extended tour d'horizon of our case. But what I've tried to do is to capture the nub of it, so that when I now deal with ground 1 and ground 2 specifically, I can tread more lightly, certainly on ground 2 and to a lesser extent ground 3. So quite a lot of the factual background I need to deploy for ground 3 before Mr. Perrott gives us the learning has already been deployed. So I hope that helps. I realise I've overshot any time for the transcriber, and I'm sorry about that. I don't know whether the court's...
Well, the transcriber hasn't asked for a break. Well, not hard-hearted if she really needs one, but it frankly helps if we can just go on. Are you all right with that? It's very nice of you, thank you.
The transcriber has suffered at my hands before, and I have promised to speak more slowly than I have done in the competition.
Well, that's going slowly or fast is a different problem. But I thought you were talking about a break.
Yes, I'm not urging the court to have one because I'm slightly behind time.
No. Well, I'm grateful to the transcriber.
May I echo that, my lord? So, delay. For my lord's note, this is dealt with in the judgment at paragraphs 134 to 159. Our skeleton is paragraphs 13 to 39.
Sorry, just give me those references again.
So judgment is 134 to 159.
Yeah.
Main skeleton from us is 13 to 39. Supplemental skeleton is 30 to 34. Secretary of State's skeleton is a very economical single paragraph, paragraph 10. But that's
because it's...
they adopt the JEAs.
Yes, quite.
The JEA skeleton is paragraphs 13 to 47. And octopus is paragraphs 27 to 41. Now, in a nutshell, our case on this is that the delay provision should not be applied in an unduly technical manner, following the judgment of Lord Lloyd Jones in the Maharaj case. The requirements governing delay should not set such a short period of time that a case ends up being not properly pleaded and not capable of being signed by a statement of truth. And that we essentially were dependent upon the provision of information in order to run a pleadable case. In terms of the legal test, I'm sure the court's very familiar with the terms of Section 31(6) of the Senior Courts Act 1981. The first part of the element of the statutory test is whether or not the claim was brought promptly or whether there was undue delay. And the second point is if there was delay, whether the court should exercise its discretion to refuse permission on the basis of it. Now, I'm not going to cover, unless my Lord would like me to, the question of relief, because we never got to relief for reasons of paragraph 133. But it may be in light of my Lord's earlier indication, I need to rejig that point over the short adjournment.
Well, just so that you understand my thinking, I'm not sure I speak for my Lord's, I'm really just thinking this out because it's not quite clear whether this had to be brought by way of judicial review at all. But assuming it did have to be brought by way of judicial review, you have two very different sorts of claims depending on the relief. If there's a quash the order, or possibly even prevent implementation, urgent interim relief, you've got to move very fast indeed. But even if it's just quash the order, clearly everybody's going on believing this is a valid order, and you've really got to have very urgent decision of the courts, whether it is or not. In that context, every day counts, certainly every week counts. If, however, this is an action for some form of financial relief, whether direct, because there is a claim for damages in here that I'm not quite clear whether that's really being pursued or how it would be pursued, or indirect financial relief, basically, which is what a recovery order would be, the degree of urgency is much less. So now, at the start, this was certainly presented as, and I'm quite sure genuinely believed to be, a claim for one form of relief, which had to be dealt with very urgently. It has now, certainly by the time in this court, though possibly also to some extent even before you, the Divisional Court, if you've been asked, actually a claim for a different sort of relief. How you approach the question of whether there was delay depends very much on what you were seeking. And just to put it to you very crudely, if you were seeking urgent relief and didn't act fast enough in the light of that, can you now come along and say, yes, all right, but that's not the kind of relief that's necessary now. What we now need is financial relief using national shorthand, and there's no great urgency about that, and we shouldn't be stopped from claiming it, simply because we didn't move fast enough at the start. That's very crude, but that's what's been worrying me, or trying to get my head around as to how you approach the question today.
With the greatest respect, I entirely see the force of that point. And it's a point I was prepared to argue on behalf of my client, then Scottish Power, now British Gas, before the Divisional Court. So I was ready to engage with the point my Lord makes, which is, well, there hasn't been undue delay, full stop. If you think there has been undue delay in seeking a particular form of relief, that form of relief is going to be refused to you in the exercise of discretion of the court. And I was perfectly prepared to have a discussion with the learned judges in the Divisional Court on that issue. Two separate issues. Firstly, has there been undue delay for the purposes of seeking permission to apply for judicial review? Secondly, if the consequence of allowing the claim for judicial review in a given formulation of relief is inimical either to good administration or to the interests of third parties, the Divisional Court would calibrate the relief granted to deal with that objection. And so I would have ended up in a position where if push came to shove, I'm no longer acting for Scottish Power, so I better be careful what I say, but certainly before the Divisional Court, I was about to engage in a discussion with the Divisional Court about what could be achieved sensibly. My primary bid for relief probably would have been get the parties to go away and discuss whether or not a surrogate competition can be run while Octopus remains in place. And if Octopus wins that surrogate competition, all well and good. If it doesn't win that competition, let's discuss what can be done to transfer customers to the party that does win the surrogate competition. Now, if that was not perceived to be acceptable, then my fallback would have been to seek declaratory relief and a recovery order, which is, to all intents and purposes, what we're seeking here.
So you're effectively saying, with all the stripping out all the caveats, that your case, if necessary, before the Divisional Court would have been all right. Delay debars me from any kind of quashing relief and rerunning relief, but it doesn't debar me from declaratory relief and a recovery order.
But the only reason I somewhat, with respect, balk at some of the parameters there is quashing can mean different things in different contexts. So it's possible for this court to make a quashing order that the funding was unlawful and therefore must be, the benefit of it must be repaid.
But I wouldn't call that quashing, though.
Well,
that's exactly what you said. That's declaratory relief,
yes,
and certain consequences of the declaration.
Well,
but the order would stand.
Well, the transfer of...
And it wouldn't be unlawful because we wouldn't have held it to be unlawful.
Well, the transfer order would stand. So the approval decision as it's framed in our claim would stand. But the funding decision would be capable of being quashed to the extent that it amounted to an unlawful subsidy, because without that declaration stroke quashing decision, you wouldn't have the necessary legal illegality for the recovery order. So you would need to make sure that that decision was recognised to have the character of unlawfulness.
Yes, but
how
I think
that's
it's
done,
right that you can have an order declared to be unlawful without quashing it.
Yes, or you could quash it, but only with prospective
Right, I think
effect.
we're probably arguing about unnecessary refinements.
I think probably I'm being too pedantic, my lord. I'll move on. So that's how I would have cut it, but we never got there for the simple reason that it was made abundantly clear to me, and even I occasionally take a judicial hint, that I was not welcome to make those submissions, and therefore I didn't make any submissions on the question of relief. Permission and delay was therefore, again, overworn phrase, the only show in town. That's the only thing I made submissions on.
Was it open to the Divisional Court to grant permission, but only for the purposes of claiming a specific form of relief?
Yes. Because relief is a separate issue. Section 31.6 is framed either as a grant of permission or relief.
You could do it two ways, couldn't you? You could say permission conditional on, and one of the conditions would be only that sort of relief. Or you could grant permission generally, but when you get to decide what relief you're going to grant, you say, well, you're too late to have this kind of relief, but you can still have that kind of relief.
Yes.
Am I right? Those are two ways of achieving the same outcome.
In principle, in my respectful submission, the more natural way would be to grant permission to run the substantive arguments that give rise to illegality, and then deal with the question of relief because it's separately itemised in Section 31.6 as a discretionary refusal of relief, notwithstanding an unlawful subsidy has been granted. But my lord's absolutely right that permission could be framed, theoretically, so that permission was given to run the substantive arguments only with a view to secure...
You say that's less natural.
You would more naturally do that where third-party interests were engaged and they needed to have certainty that there wouldn't be a quashing order.
My lord's
So
absolutely...
I suspect in this type of situation, any reasonable judge at first instance, if granted permission, would make that clear.
That's, if I may say so, a very helpful practical intervention. That's certainly one way in which, in order to stop scaring the third-party interests, the court would make it clear that the only issue was going to be a recovery order in due course. But it's two paths up the same mountain. Now, in terms of the legal approach to delay, please could I invite the court to consider the judgment of Lord Lloyd-Jones and the Privy Council in the Maharaj case. This is Bundle of Authorities, tab 3, page tab 37, starting, please, at page 200. It's clearly not right. It's not 200, I'm sorry. It's tab 37 and page 1548. some rather convoluted underlying facts in the context of proceedings brought in Trinidad and Tobago. I think it was a promotion of a police officer. No, sorry, it's a FOIA request and a refusal. But anyway, the points of principle are set out without needing to understand the underlying facts. Please could I invite the court to read paragraphs 29 to 31, starting at page 1548.
Yes.
And would the court then be kind enough to read 36 to 38? That's page 1550. So the issue of detriment arising from the delay necessarily features throughout the considerations that are being made. But of course that means that it's detriment as a result of delay in permission being given, rather than delay in the outcome of any particular case leading to problems with the relief that is going to be the focus of our submission. Now, could I please then invite the court very briefly to consider a decision of this court in Crown on the application of Young and Oxford City Council. That's it, Bundle of Authorities, Bundle 1, tab 13. Picking up, please, at page 292. It's Bundle of Authorities 1, tab 13. Page 292. This claim arose in the course of a planning issue. The learned judge at first instance had concluded that the date of the council resolution was the start date for time running, and in fact it was found in the House of Lords in the Burkitt decision, I think, to be the date of the actual grant of planning permission that was the trigger. But in any event, the judge considered that the delay justified the refusal of permission in this case. The Court of Appeal at paragraph 31 noted that the judge had used the wrong start date in the light of Burkitt, and that the claim had therefore been brought within the 3-month period. And then the issue was whether or not the claim, notwithstanding that it was brought within 3 months, had in any event been brought promptly. The relevant principles are set out in terms of relevant factors to consider in whether or not there's been undue delay. Paragraphs 33 and 34. Please would my lords read paragraph 33 and 34.
Yes.
Then within the judgment of Lord Justice Potter, please, at page 294, would the court read 43 and 44, paragraphs 43 and 44.
Yes.
Now, in terms of the finding that there has been undue delay in this case, I'm proposing to set out reasons why, with the greatest respect, that conclusion is clearly wrong. Just for my Lord's note, the funding decision was published on the 29th of October 2022, and I'm going to take the court briefly to it so that you can see it in situ. And the approval decision for the ETS was taken on the 7th of November 2022. British Gas claim was brought on the 28th of November 2022, and the E.ON claim was brought on the 29th of November 2022. British Gas applied for urgency. For my Lord's note, that's Supplemental Bundle tab 18, page 433. And British Gas specifically sought a directions hearing in the week commencing the 5th of December 2022 to allow matters to be considered urgently. That's Supplemental Bundle 18, page 441. E.ON also sought urgent treatment. That's SB Supplemental Bundle 19, page 446. Now, I'm going to start, if I may, with references in the judgment itself to the first point at which press reporting emerged about the possibility of a subsidy. And this is dealt with in the court's judgment, Divisional Court's judgment, paragraph 72, Roman 9, which is page 119 of the core bundle, tab 7. So this is Divisional Court judgment, paragraph 72, subparagraph 9. It refers to some text from Mr. O'Shea of British Gas, referring to press stories suggesting that a company and Octopus were bidding. This was a reference to a well-informed report which had appeared in the Financial Times that day, alleging that Octopus was in negotiations to buy the bulk business and that HMG was expected to offer a clean balance sheet with no debt, as well as a generous financial dowry. Albeit, and this is the qualification, government has not set out how much money it would be prepared to inject in the deal, and is instead waiting to see what the three bidders offer. Quite sure who the third bidder was at that stage. But that was a press report at the end of July. But the Divisional Court at paragraph 142, page
Is
1...
Is that July?
I think the Financial Times report was the end of July.
Talk about text messages. The text messages.
I'm sorry, you're right. That would put it at June.
Yeah.
June 2022. I think there was some further press reporting at the end of July, which led to further correspondence, which is why I've confused in my head the date. The Divisional Court dealt with this at page 140, paragraph 142. And there was a letter from British Gas that the Divisional Court referred to, in which it had referred to the potential unlawfulness of any subsidy being referred to. But it said at that stage no decisions had been taken.
So, sorry, which paragraph are we on?
142.
Yeah.
At that stage no decisions had been taken and the claimants were reliant upon press reports. We do not suggest that applications for judicial review should be commenced on the basis of press reports. So it doesn't appear to be being suggested that we had sufficient information as at 12th of August 2022 to make out a case. And any such case we respectfully suggest would not only have been speculative, but premature, because of course no decision had been taken at this stage. Now, we then move forward to a letter from Scottish Power on the 11th of October 2022. This is in, please, supplemental bundle tab 43, which is in bundle 3, at page 616.
Yeah.
And Scottish Power is again referring only to press reports over the weekend indicating that £1 billion worth of taxpayer funding is being offered by the Treasury to Octopus in connection with its purchase of Bulb. No other supplier in the UK has access to such government funding. And then they were concerned that Scottish Power had not been told about that funding in the course of the process that had been run. Now, as I've said, no final decision was then taken on the subsidy until it was published on the 29th of October 2022. My lords will find that at tab 48 of this bundle. This is a press release that confirms that the UK government has approved an agreement between Bulb and Octopus, providing certainty for 1.5 million customers, it says. In terms of what is said about the financing, page 695, bottom of the page, simply says the government will provide the remaining funding necessary to ensure that the special administration is wound up in a way that protects customers' supply. Now, just pausing there. The government had been funding the energy administration. So that doesn't suggest that Hiveco or Octopus has been given funding by the state. It then says the government can recoup these costs at a later date, ensuring that we get the best outcome for Bulb's customer and the British taxpayer.
Sorry, just your observation on the first sentence was what?
It simply says it's providing funding to ensure that the special administration is wound up in a way that protects customers' supplies. So
What do you say that omits to say? You said that doesn't say...
Well, it implies that the funding is being provided to the special administrators, who are the JEAs. And there's a separate facility that is indeed made available to the JEAs that's part of the rescue subsidy. And one could infer that that's a continuation of the rescue package that's been put together with the energy administration to enable the company to come out of energy administration. It doesn't say, by the way, we're giving...
Yeah, I get the point, yeah.
Page 697, then, please. We have slightly more detail. Second and third bullet points on that page. This is a statement coming off the fence and being clearer. The government will provide financial support to the new entity for the procurement of energy for Bulb customers over the course of winter 2022. This financial support will be repaid by the new entity in accordance with an agreed repayment schedule. And says a profit share agreement will be put in place for the ring fence business until agreed funding is repaid by Octopus. So that doesn't, with respect, tell you whether or not this is a commercial loan on commercial terms to the new company to enable it to obtain capital financing to fund the necessary wholesale purchases to see the customers through the winter hump. The final ETS decision was taken on the 7th of November 2022. As a matter of fact, it wasn't disclosed until the 9th of November 2022. Now, in contrast to this, these are the official decisions. Tab 49, page 701. We have a letter from British Gas to Ofgem, in this instance, referring to the first announcement I took you to, the press release of the 29th of October, and asking for its concerns to be addressed by Ofgem. And we see at page 703, paragraph 11, there's a detailed request for information and documentation to get a better idea of what's going on. The separate letter is then sent by British Gas, tab 50, page 704. In the second paragraph, it refers to its initial concerns about potential government subsidy that had been raised on the basis of press reports. And it notes that
who are the different ones to Ofgem? And
one's to Ofgem and one's to the Secretary of State.
Yeah.
So 704, second paragraph, refers back to the 12th of August letter, which had been based on press reports and asked for clarification on the basis of the press report, to which no answer has ever been provided. And then overleaf, please, at page 705. There's a complaint about the clarity or lack of clarity and therefore transparency from the press release. And it says what decisions they refer to, who in government is making them, and or pursuant to which legal process they relate. It's also reported that the proposed transaction will include providing a significant financial support in the form of a loan by the government to Octopus, which was not articulated or disclosed as part of the public tender process, as part of the competition run by the Special Administrator. Now, just pausing there, British Gas has read the press release as implying that a loan has been given to the new company, which will be repaid. And we know, because I've shown the court earlier, both in the judgment, the Divisional Court's judgment, and in some of the surrounding press release material, that the subsidy that's provided is far more detailed than simply a commercial loan to be repaid. There was no commercial loan, there was a loan, but there was no interest. And of course, the devil is in the detail in subsidy matters. If it was indeed a commercial loan at a commercial rate, it wouldn't be a subsidy, because it would be a market transaction capable of satisfying the CMO principle that Mr. Peretz will take you through later. Now, we then see a paragraph 9 of this.
You said understood to be a loan. They're pretty skeptical about what sort of a loan it is, as you see it for.
Yes. And that's what drives then at paragraph 6, a request for disclosure of the proposed transaction structure. How's it going? What restrictions will be applied to the ring-fence business? What security or collateral is being provided, and so on. There's then some complaints about the capitalisation of Octopus as an entity, which I needn't dwell on. And then overleaf, please, page 707, paragraph 9. And we see in subparagraph B, having complained about whether or not it's a transparent, accountable and proportionate measure, Centrica is concerned that the loan proposed to be provided to Octopus, which we assume relates to the need to put in place appropriate hedging arrangements arising from the government's failure to hedge the bulk customer book, constitutes a significant subsidy for the purpose of UK subsidy control legal framework. If that is correct, the subsidy process followed in approving the agreement is unlikely to be compatible with the legal framework. Now, just pausing there, with the greatest respect, that isn't something that I would have been able to plead as counsel.
Sorry, I didn't.
I couldn't have pleaded that as an arguable ground for a claim at that stage. That's the short point. I hope I'm not alone in that. If we then please look at paragraph 10, and specifically subparagraphs G onwards at page 710.
Are you coming back to what you could and couldn't have pleaded?
Yes.
Right.
Subparagraph G, British Gas is asking Secretary of State to identify the date of the government's decision approving the agreement and provide a copy, asking for the approval and the transaction details to be provided, details of the ring fencing arrangements, and then specifically at subparagraph N, provide sufficient information in respect to the subsidy proposed to be provided in the form of a loan facility or financial support in accordance with Article 3693 of the TCA. Now, that particular provision of the TCA puts in place a mechanism by which somebody who is an interested party is entitled to request details of the subsidy from government, and then until such time as the information is provided, time doesn't start to run for the purposes of challenging the subsidy decision. And that's echoed then in the Subsidy Control Act provisions as well. So this is a formal request for information under the TCA. Specific reference is made to the need to comply with the principles. And therefore, this is very clearly marking that we want to be able to assure ourselves that you have complied with those principles. But in order to do that exercise of analysis, we need to know what is the basis for your decision. Now, a parallel letter was sent by Scottish Power. That's at tab 52. I don't think I need to dwell on that. They've chosen not to appeal. And then a parallel letter is also sent by E.ON, page 716. And that too, see 717, 718 raises issues of fair and due process, state subsidy, and concludes with next steps, page 719. In the interest of transparency and assuaging our concerns, we ask the government provides us with all of the information evidencing the compliance of the subsidy package with subsidy control requirements as a matter of urgency. So they too are formally requesting details of the subsidy to enable a potential challenge to be considered. Now, in terms of response to that, we say the response, I'm afraid, from the Secretary of State was both very delayed and didn't meet the requirements of providing us with sufficient details to enable a challenge to be brought. If we look, please, at tab 56, page 734. Third paragraph down, this is a letter to Scottish Power's Chief Executive by the senior official at the department. I'm advised that a typical competitive bid process delivered by the energy administrators and M&A was followed. They provided flexibility, the process remained open, exclusivity was not granted, and so on. We then see over the page at 735, second paragraph, the transaction is conditional upon the approval of the Secretary of State and will not be complete until a time has been appointed by the court. Now, we're not at this stage, or Scottish Power, I'm sorry, was not told at this stage that an approval decision had been made that day. And we then see in the second to last paragraph, I can confirm.
Sorry, yes, so this was wrong.
Well, it depends when she wrote the letter.
Yes, I see.
If she wrote it first thing, then it might not have been. But when the letter is going out to an interested party, it's not massively helpful.
Because you would expect if she would certainly known the hearing was that day.
Well, she would have. Well, the hearing was on the 10th, I think, of November. So that was.
Oh, I'm sorry, I'm at cross purposes. When did you say?
So the ETS approval was given on the 7th of November, but Scottish Power certainly was not notified of it until I think the 9th or 10th. Now, in the second to last paragraph, the senior civil servant decided to treat this as a request for further information under the relevant legislation, which in context meant either the Freedom of Information Act or the relevant environmental regulations that give an entitlement to environmental information. Now, in parallel to that, at page 736, a separate letter was sent to British Gas by the same official. And this is the first reference to British Gas's letter of the 12th of August. So we see, thank you for your letters of 12th of August and 3rd of November. Please accept my sincere apologies for the delay in response to your 12th of August letter. It said it was sent to the wrong address. Well, there are various reasons why Mr. Raj Roy in his witness evidence says that was not right and that other people had obviously received it, but I'm not going to get caught up in that now. What we say is telling is in the second paragraph, you will appreciate your letters raise numerous matters and pose several questions which is not possible to address within such a time frame. It's unclear why your letter imposes this deadline, and I invite you to clarify whether the urgency is due to an anticipated legal challenge by Centrica. Well, that's suggesting that the issue is not urgent and that it doesn't need to be treated as a priority. We then see at paragraph 737, sorry, page 737, last paragraph on the page, turning to the request for information in paragraph 10 of your letter, it said that this particular letter addresses a number of points. It's unclear why other information has been requested. And please could you clarify on what grounds you are suggesting Centrica may challenge a decision of the Secretary of State? So, and I don't mean this pejorative, this is a classic Stonewall response to a request for information. In context, it was distinctly unhelpful, especially when it gets replayed to us as somehow we're dragging our feet.
Could you repeat the last bullet point?
Mr. Perrotts invites me to draw to your attention the last bullet point.
Which is the piece of
in respect of the request for the subsidy issues, subject to completion of the transaction. So again, it's being suggested that the transaction is not yet complete, even though this is sent on the 7th of November. The revised funding facility between the government and Bulb will be published on the government subsidy transparency database in compliance with Article 369. That's the document I took you to when explaining the nature of the subsidy, published on the 21st of December 2022, some 3 weeks plus after the claims have been issued.
Just give us the reference for that.
That was
I think it's page 807.
SB supplemental bundle tab 71, page 807. Thank you.
Thank you.
I'm conscious of the time, but if I can just squeeze this one.
You've got time for one more document, I think.
And then I'll pull up stumps momentarily. The next one, please, tab 58, page 739. Letter to E.ON, 8th of November, second paragraph. You raise numerous matters and pose several questions. It's unclear why your letter imposes this deadline. I invite you to clarify the nature of the urgency. And then again, a similar hold the line, give details of what is being done, but not actually any substance on the subsidy position is taken. My lords, that is probably a convenient moment, subject to your lordships.
Yes, very well. Thank you very much. 2 o'clock.
Court rise if favourable.